Hello, this is Black Formation, where you don't need to be black to get information or information. Today's topics will be the Supreme Court, qualified immunity, and black people. In 1961, a case called Monroe versus Pape, where a black family, the Monroes, sued Chicago police officers. This case is interesting for many reasons, but for this we will look at the obvious, that being the time it took place, and the family, of course, is black. It looked like a glimpse of progress. The courts traditionally have not been particularly sympathetic to black Americans. This happened a few years after the Brown versus Board. This is a few years before the Voting Rights Act. This is an era where the Supreme Court at least had some short-lived moments of clarity around race in America, or so it seemed. In 1967, Miami Police Chief Walter Headley coined the phrase, quote, "when the looting starts, the shooting starts," end quote. While cracking down on black neighborhoods, 2 states over in Mississippi, the police had arrested a group of black clergymen for peacefully using a whites-only waiting room in a bus terminal. When the clergymen tried to sue the police for violating their civil rights, the court ruled the officers shouldn't face legal liability for enforcing the law in good faith and with probable cause. Qualified immunity was born. 15 years later, in 1982, a decision in court case Harlow versus Fitzgerald, a case involving Air Force contractor A. Ernest Fitzgerald, a whistleblower who alleged that a new fleet of aircraft had gone $2 billion over budget. This case was about Fitzgerald trying to sue former President Nixon for getting him fired in 1970 after whistleblowing. Nixon was found to have presidential immunity. The question was whether or not his aides did as well. The court ruled, quote, "Government officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights which a reasonable person would have known," end quote. This is where the, quote-unquote, clearly established part was born, where now it matters not if the officer acted in good faith, even if the officers or officials act maliciously and violate someone's constitutional rights. They can only be sued when evidence shows that the official violated, quote-unquote, clearly established law. What qualified immunity does is it makes it difficult for people to bring suits against police, much less win them. As an example, let's look at the case of Seattle resident Malaika Brooks. In 2004, Brooks, a 7-month pregnant black woman, was pulled over by police for speeding while driving her 11-year-old son to school. Brooks believed she had been wrongly stopped and refused to sign the ticket, mistakenly thinking that her signature was an admission of guilt. Refusing to sign was a crime, and the 2 officers on the scene summoned a sergeant who instructed them to arrest Brooks. She would not get out of the car. The officers then threatened to throw her in jail, twisted her arm behind her back, and tased her 3 times, first on her thigh, her arm, and then in her neck. All this before dragging her in the street, laying her face down and cuffing her. In the months that followed, Brooks gave birth to a healthy baby girl, was convicted of refusing to sign the ticket, a misdemeanor, but not of resisting arrest, and sued the officers who tased her while pregnant 3 times, causing her intense pain and leaving her with permanent scars. Brooks sued the officers, and in 2011, a federal appeals court argued that a reasonable person could conclude that the officers had indeed violated her constitutional rights. But those same judges dismissed her case, arguing that no precedent had been clearly established. In recent years, legal scholars, judges, and justices on all sides of the ideological spectrum have criticized the legal doctrine of qualified immunity, arguing that it is not grounded in the proper legal authorities and too often shields officials from accountability. Qualified immunity sends messages to government officials that there are no consequences for violating the law, and to people that their rights do not matter. This applies to members of law enforcement, public school officials, city council members, or other municipal employees. It seems like the U.S. tests out its tools of oppression on black people. What they do to us today, they will do to you tomorrow. All lives can't matter until black ones do. You can find this full article on the Black Formation Facebook page. It was written on October 21st. More videos will be coming soon. Thank you for making it this far. If you did, please leave a like, comment, and subscribe for more videos in the future.